Hi, I'm J. Christian Adams, president of the Public Interest Legal Foundation. This is the Protecting Your Vote podcast. For more information, you can always go to publicinterestlegal.org. With us today on our podcast is actually the chairman of the board, Frank Sinatra. No, I'm kidding. It is not Frank Sinatra. It is Hans von Spakovsky. How are you doing, Hans?
I'm doing fine, Christian.
Frank was a big movie star, wasn't he?
Yeah, he was.
Was he ever not? He was nominated for an Academy Award, I think.
I'm sure he was. But yeah, he made a lot of movies, and he made some very, as you know, some very fun ones with Dean Martin and the rest of the Rat Pack.
Right. Boy, what a force of nature he was in Hollywood. There weren't many like him that were doing Elvis, Bing Crosby, of course.
Yeah, people don't you talk to any Generation Z or today, they have no idea who Bing Crosby was. He was the best-selling singer in America for a long, long time.
He remains so. The biggest selling single of all time, the most records sold of anything. You know what it is?
No, I have to admit I don't.
White Christmas.
Yeah, okay, that makes sense.
It's a Bing Crosby. Actually, this is an election podcast, believe it or not. We've only stumbled into the movie discussion. What we're going to talk about today, it's the summer's coming to an end, the fall is starting.
That's right.
And that always means the Supreme Court is cranking up another term in the Supreme Court. As a matter of fact, PILF just filed a brief in one of these cases. There's a couple of big election law cases we ought to talk about so people understand them. You always kind of, when you read the newspaper, it's a sure sign you don't understand the case.
Well, and often, you and I both know, the reporters don't understand what they're writing about because they make so many mistakes when they talk about what's actually going on in these election cases.
So we have two cases. I'll just tell you a summary quick off the top. One is out of Louisiana. It's a redistricting case.
Right.
And another addresses the First Amendment relating to campaign finance restrictions under the First Amendment and the ability for parties to get their message out.
Yeah, and that one's interesting because it was filed by then Senator J.D. Vance, who's now the Vice President of the United States.
So what do you want to talk about first? Which one?
Well, let's talk about the redistricting.
Okay. So not long ago, just literally in the Supreme Court filing system, was filing Public Interest Legal Foundation's brief in this case. We represent 7 Louisiana legislators, or our clients, who were on the floor of the legislature when this law was passed, and they understand this was a racially motivated map.
Right, but racially motivated because the court was telling them to do it, which brings up the whole conflict in this case. We should say Louisiana versus Callais, right?
Yeah, Louisiana versus Callais.
Yeah, and look, Louisiana had, six congressional districts. They've had those for a long time. And years ago, maybe the 1990s, decades ago, they got sued, and they were told by a court back then, well, of your 6, you got to have one of them be a majority-minority district, right? One in which black voters are majority so they can elect their candidate of choice. So after the last census, Louisiana... They did draw new boundary lines, right? And they created the new lines for their 6 districts. And once again, they created one majority-minority black district. And I can't remember who sued them. Was it the NAACP? They're usually the culprits.
Somebody named Robinson. I could tell you that much because that's the name of the other case.
Okay.
The first case.
So
it's called Mrs. Robinson.
Right. So they get sued.
Another movie reference, by the way.
Yeah, I know that one. So they get sued, the state gets sued, and the plaintiffs say, well, the black population in Louisiana is 35%, so we should get 2 of those 6 districts. And a judge agreed with them. He didn't really, as I recall, there wasn't really evidence that in that first case, there wasn't evidence of current discrimination, right, that would have justified under the Voting Rights Act saying, well, you got to remedy it by creating a second district. Was there?
It's even worse, too. It was a preliminary injunction done on a very fast track. It was not a final judgment.
Okay, right.
This is an important part of the case.
Yeah. Because
the legislators, as I understand it, again, we filed on behalf of 7 legislators, they were being sold a bill of goods behind closed doors that the judge was forcing us to do this. We had to do this. Oh, no. It was a preliminary injunction. Yeah.
Gosh.
You see?
And what people need to understand is, look, this lawsuit was filed under Section 2 of the Voting Rights Act. Section 2 bans, racial discriminating in the voting contest, but for decades now, because there really isn't any racial discrimination in the voting context when it comes to keeping people, for example, out of polling places or keeping them registered, which was what the law was originally designed to do. It's been used to argue that people's votes have been diluted. And that was, I think, the argument here. But Section 2 has a very special line that says, Section 2 does not entitle people to proportional representation. So you aren't supposed to be able to go to court and say, well, our racial group is, 50% of the population, therefore we have to be given half the congressional districts. But that seems to be what the judge told Louisiana to do, right?
Yeah, and this takes us back to 1982 when the amendment was passed to create this sort of claim. Congress was very explicit that proportionality was not what this amendment was about. 1982, I think that was Chariots of Fire was Best Picture that year. To keep this going throughout.
Yeah, movies keep coming into this. Right?
And so the district court in the Mrs. Robinson case never had a final ruling. So what happened is certain people in Louisiana then went to the legislature and said, we have to draw a second black district. Mm-hmm. We have to draw a second black district. And that was what the word was on the floor. This has to be another black district. Well, guess what? You can't speak in those terms without violating the 15th Amendment. And that's what our brief says. Right.
But so the legislature basically does it. They come up with now two majority-minority districts where black voters can supposedly elect their candidate of choice, and they get a second lawsuit, right?
Right. That's what's so funny about this case. So a group of voters who didn't want them drawing on the basis of race sued, and they actually got a 3-judge panel, and the 3-judge panel heard a mini trial, heard all this evidence about what was being said in Baton Rouge, that this is explicitly a racial district, and struck down the racial draw. Said you can't draw a second district that's supposed to just be black.
Right. So Louisiana is stuck between, well, you had one court saying, well, yeah, you're supposed to draw up this second district, and then another court saying, well, yeah, you drew up a second district, but you did it in a discriminatory manner. I mean, they're stuck, right, between two different courts telling them two different, totally conflicting things.
And it would have been different had that first case, the Mrs. Robinson case, had actually gone to an actual real trial and judgment.
Right.
That would have made a difference here. Right. But of course, the court could have then imposed the district. It didn't need to go to the Louisiana legislature. Courts have the power to redraw maps, right, in a remedial phase. So this case got bollocksed up in great measure because this idea that they had to do what no judge ordered them to do.
Right.
No judge had said you have to draw a second black district as a final matter, but yet that's what was said in the State House.
So now Supreme Court has accepted the case. They're going to decide it. Have they said?
Oh, there's another quirk here. There's a sequel, isn't there, in this case? They argued this in the spring.
Right. Yes. Yeah, it was already up. It was already up before the Supreme Court last term. I'd forgotten about that.
Yeah, it's like The Empire Strikes Back. I mean, they go to a sequel, and the court says what it almost never does, hey, you know what? Come back in the fall and re-argue this again.
Yeah, because June 30th is when the court ends its term before they all take their summer break. That's usually when their most important decisions come out. So everybody's waiting for this decision. Yeah. And instead we get an order saying, no, we're going to put this off. We're not going to argue it until the fall. And we want a second round of briefs filed. In fact, that's very rare. The last time I remember that happening was the Citizens United decision. That one they set for a second argument. And in the meantime, in the Citizens United decision, in the meantime, Elena Kagan, who's now a justice, had been named by the Obama administration to be the new Solicitor General. So she went to the Supreme Court to argue that case. She had never argued any case in any court ever before. She had she'd been the dean of the Harvard Law School. She had no experience in court. And she shows up, I was actually there, shows up at the Supreme Court as the Solicitor General arguing one of the most important First Amendment cases in decades.
Wow.
Totally got flattened by the lawyers on the other side of the case, which were Floyd Abrams and Ted Olson, two of the best First Amendment lawyers we've ever had in our history. And they were up against Elena Kagan. It was shortly after that she went to the Supreme Court. But
wow.
No.
So that's a great segue into our second Supreme Court case on the docket this fall. And that involves the First Amendment. And it sort of has its origin with J.D. Vance.
Yeah. And I know a bit more about this case because I used to be on the Federal Election Commission as a commissioner. And one of the laws that we enforced was back when they put in all these supposed campaign finance reforms, Congress put a limit on how much money a political party could spend helping its candidates, which just is kind of crazy to me to start with, because the whole point of a political party, right, is to help its candidate.
You only get so much speech.
Yeah, exactly.
And then you're cut off.
Right.
No more.
Right. So a number of years ago, the Supreme Court issued a decision saying, well, as long as it's independent spending by the political party, you can spend as much as they want. In other words, if they're not coordinating with the candidate, they're not talking to the candidate, they're coming up with their own ads, for example. But they left in place the limit that says when you're coordinating with your candidate, you can only spend a certain amount of money.
What is that amount? Do you know off the top of your head?
Off the top of my head, I don't remember, but it's not that much.
Really?
And the FEC always, this was a difficult law to enforce because how do you figure out if people are coordinating?
Yeah, right.
You know, if they appear at the same fundraising dinner, well, do we assume they then coordinated and secretly talked about that ad there? It was a difficult law to enforce. So J.D. Vance and the Republican Senatorial Committees, that's the committee that tries to get U.S. senators reelected on the Republican side, they sued saying, look, this particular provision really can't stand given the prior decisions you all have made in recent years, like in Citizens United, that have given greater leeway, greater strength to the First Amendment. And the lower courts ruled against Vance, ruled against the Republicans, saying, well, we're bound by precedent. But in fact, the Court of Appeals in the case said, well, we're following the precedent of the Supreme Court, which previously upheld this, but this law no longer seems to, there's kind of a conflict between this law and those more recent decisions.
Right. And this one seems like a cleaner case. Like it's built on the prior decision with Citizens United. It's hard for me to understand how the law stands. Like I'm trying to think, how could this survive? Perhaps.
Well, I don't think it. Look, I don't think it can. You know, what's interesting about that case is that, if you go back to Alex de Tocqueville, right, his terrific book that he wrote about America, there's this whole section in there about association.
Yeah.
You know, he talks about how different Americans are. He said in Europe, when there's a problem, everyone expected the government to take care of it. And he said, in America, people form associations of all kinds. And a political party, it's an association. And if they are trying to get a member of their association elected, you know, how can it be not a violation of the First Amendment to tell them, well, you can only do a certain amount of associating
right.
with that person.
No more association after this much.
Yeah, exactly. Yeah. And that's what
Break it up.
To. So yeah. I suspect that that particular provision is going to get federal laws are going to get tossed out.
Why did that not show up in the original challenges to the campaign finance laws? I wonder how that slipped through.
It's just, if you look at the last 20 years in challenges to federal campaign finance laws, it's been they've bitten off one piece at a time, trying to get rid of what I consider to be bad provisions that actually restrict the political speech, political activity of America.
Is my memory correct on that? President Bush signed that law, but had a statement saying he thought it was unconstitutional. Am I right about that?
Yeah. Yeah.
What in the world?
Yeah. In fact, what's funny about this is, about that very fact, is that that this was the big bipartisan campaign reform bill that Senator McCain pushed, right?
Yeah.
And so during the Bush administration, the law gets challenged at the Supreme Court. And who's the Solicitor General? Ted Olson.
Yeah.
He goes and he defends it. And the Supreme Court pretty much upheld most of it, right? Well, remember how I was talking previously about Citizens United decision and how the plaintiffs who challenged it had Floyd Abrams and Ted Olson on their side because Ted Olson was gone from the government. In that case, Ted Olson was arguing that the provisions that he had previously argued were constitutional. When he was the Solicitor General of the Bush administration, he was now in court representing private parties, arguing that they were unconstitutional, and he won both times.
Oh my gosh, you're right. Right.
I'm not sure if there's another example of a lawyer going before the Supreme Court arguing the very same issue, once in favor, once against, and both times winning.
Yeah, right. #winning.
Yeah.
Yeah. I'm with Hans von Spakovsky. I don't know if you noticed, Hans, but your book is on the PILF shelf back there.
I see that.
You see that?
That's
back
good.
there? We took down the Rick Hazen book. We noticed the books were yelling at each other.
Yeah,
and
so that's probably
anyhow. You have been listening to Protecting Your Vote. I'm J. Christian Adams. Thank you so much, Hans, for joining us. It's been a pleasure. And don't forget to like us down below this way, right down there. This is Protecting Your Vote. For more information, go to publicinterestlegal.org. Thank you much.